Welcome to Using ABA Model Rule 8.4G to Advance Diversity, Equity, and Inclusion in the Legal Profession. My name is Germán Gomez, and I am the Chief Human Resources Officer for Hogan Lovells in the Americas. Racial and gender inequities still exist in the legal profession. Researchers are starting to look at potential factors to explain why these inequities still exist. Many researchers now believe that bias in the workplace is one key factor for those inequities. Bias takes many forms, but the result is always the same. Members of a certain demographic group within the workforce that are wrongly excluded from experiences and opportunities for which they are qualified. The biases people harbor, whether consciously or in their subconscious, cause them to have attitudes about other people based on characteristics such as race, ethnicity, age, gender, and appearance. And they bring these irrelevant factors into the decision-making process. These biases play a role in personal assessments of candidates and employees and influence the decisions to hire, fire, and promote within the legal workplace. That these influences may be unintentional does not change the fact that they are unfair. The negative effects of bias in the legal profession or elsewhere can be destructive, and they can affect every aspect of the employment lifecycle from hiring to firing. Bias not only affects the employment lifecycle, but also has the potential to negatively affect daily common interactions within the legal profession. For example, instances like representing clients, interacting with witnesses, relationships with opposing counsel, interacting with coworkers and court personnel, and finally, attending functions related to your law firm or your law practice. Ultimately, this bias affects the legal profession in a manner that negatively impacts women and minorities in the profession. For example, bias in resumes with ethnic-sounding names result in them being pushed down for selection for interview. Research shows that more women are interrupted in business meetings than men are. Women law partners earn approximately 30% less than male partners. A recent study done on a memorandum of law written by a Black associate determined that it was evaluated more critical than an identical memorandum written by a white associate. Women are held to tougher standards than male lawyers when it comes to anger. Women and minority judicial candidates are systematically receiving lower qualifications rating from the MBA than do their white male counterparts with identical qualifications. Female Supreme Court justices are interrupted more often than male justices. Women's performance reviews are more likely to include critical feedback and negative personality criticism than those of men. Lawyers of color constituted more than 20% of the lawyers who left their firms in 2018, even though they represented only 7% of the lawyers in that particular law firm. More than 31% of all first and second year lawyers who left their firms in 2018 were members of a racial or ethnic minority group. Minority lawyers also represented 30% of all departures among mid-level associates, those which are third through fifth years, and 20% of senior associates, which are those from sixth, seventh, and the eighth year. Although women represented only 36% of the lawyers in the law firm surveyed, more than 49% of all the first and second years who left their firms were women. Women also represented 46% of all departures among mid-level associates and 46% of senior associates who departed in 2018. While at the three leading arbitral entities, fewer than 30% of available arbiters are women. 66% of lead counsel in civil cases are men. 87% of lead counsel in class actions are men. And 90% of attorneys serving on firm executive or management committees are white. So what is the end result? You have a profession that, according to the US Bureau of Labor Statistics for 2020, is 87% white, as compared to 78% for architects and engineers, 77% for accountants, and 82% for surgeons. Having said all that, we must acknowledge that no disciplinary rule or process can correct the structural, institutional, and unconscious biases described above. However, it is important to understand that these kinds of biases, in order to understand why these legal profession inequities exist today and why our profession looks the way that it does. Additionally, the fact that bias exists and impacts the ability of many lawyers to succeed in the profession is all the more reason for a bar of any state to take the steps necessary that are within its power to promote diversity, equity, and inclusion within the profession, such as adopting the anti-harassment and anti-discrimination rule created under Model Rule 8.4G. After 2 years of intensive study and debate, ABA Model Rule 8.4G was adopted in August of 2016. The new black letter provision replaces existing comment language as well. The black letter rule now extends anti-harassment and anti-discrimination to the practice of law and not just to the administration of justice. So what does harassment and discrimination mean under this model rule? Prohibits conduct that can be verbal or physical, prohibits conduct that undermines confidence in the legal profession and legal system, defines harassment as being derogatory or demeaning conduct, and sexual harassment is broadly defined. What does related to the practice of law mean? Well, under Common 4, it defines it extremely broad. If the conduct is in some way related to the practice of law, it falls within the rule. So what does ABA Model Rule 8.4G not do? It does not limit advocacy in any way not already encompassed in the model rules of professional conduct or other applicable rules and court rules. It does not inhibit a lawyer's ability to represent a client or to argue a position for the client. It does not prohibit legitimate advice or advocacy consistent with the model rules of professional conduct. A trial judge finding that peremptory challenges were exercised on a discriminatory basis does not alone establish a violation of this rule. Promoting diversity does not violate this rule. Focusing on a particular practice area does not violate this rule. Focusing on an underserved population does not violate this rule. Limiting your practice to clients who can pay you reasonable rates does not violate this rule. So what are the safeguards in the enforcement of 8.4G? Well, the burden of proof still remains with disciplinary prosecutor. Conduct must meet definitions of knows or reasonably should know, which are the same standard applied to many legal proceedings and other rules of professional conduct. Conduct must also be examined in relation to the practice of law. How does ABA Model Rule 8.4G help the legal profession? Well, it helps the profession with public perception. It also helps lawyers with a clear definition and parameters of what is prohibited, even though some of this conduct is already prohibited by law. It sets out guidelines and comments to protect the operation of the law practice and the right of free speech, thought, and association of religious, and it limits its application to conduct related to practice of law. So why should more jurisdictions adopt ABA Model Rule 8.4G? Well, lawyers, judges, clients, and the public benefit when the legal system is fair and unbiased. Positive public perception of an unbiased system assists the operation of the courts and the practice of law. Lawyers should engage in conduct that promotes the good of the profession, and these professions assist lawyers in complying with this goal when they are engaged in the practice of law. And consistent rules from jurisdiction to jurisdiction will aid practitioners and their clients engage in interstate business to act and conduct themselves in the appropriate manner. So what have been the responses by other states to 8.4G? Well, Vermont adopted the rule verbatim effective September 2017. Colorado, Missouri, Maine, New Hampshire, New Mexico, and Pennsylvania have recently amended their rules of professional conduct to closely align with Model Rule 8.4G with some minor modifications. California adopted a rule that prohibits a lawyer from unlawfully harassing or discriminating in connection with the representation of a client or the operation of a law firm. However, there has been much objection to this rule as well. States like Arizona, Idaho, Louisiana, Montana, Nevada, North Dakota, Texas have all objected to the rule under First Amendment principles. Many have argued that the rule violates the First Amendment because it has a chilling effect on the ability to participate in debates in the context of continuing legal education classes and elsewhere on controversial issues of public importance, such as same-sex marriage, gender identity, and bathroom selection, or restriction of immigrants from Muslim countries. These objectors are concerned that the expression of opinions that others might find offensive raises a risk of disciplinary charges for violating the model rule. However, ABA Model Rule 8.4G is not intended to chill speech on controversial topics, but rather to prohibit the discriminatory conduct directed at a person or persons by a lawyer with respect to the practice of law. A general point of view, even a controversial one, cannot be reasonably understood to be considered as harassment or discrimination. The fact that others may find a lawyer's expression of social or political views to be inaccurate, offensive, or upsetting is not the type of harm required for a violation. Also, 22 states and the District of Columbia have already adopted anti-discrimination and/or anti-harassment provisions into black letter of the rules of professional conduct. And there have been no negative effects from these adoption of such rules. In fact, the ABA report notes that the Supreme Courts of the jurisdictions that have black letter rules with anti-discrimination and anti-harassment provisions have not seen a surge of complaints based on these provisions. Also, lawyer speech has long been subject to additional restrictions that are viewed as necessary to the integrity of the judicial system. For example, a lawyer may not reveal client confidences or secrets. A lawyer may not make a false statement or fact or law to a tribunal. A lawyer may not communicate ex parte with a judge or a juror during a proceeding. A lawyer may not make potentially prejudicial extrajudicial statements about a case. A lawyer may not make false statements of material fact or a law to third persons. A lawyer may not communicate directly with represented persons or solicit business near a courthouse. None of these rules or the associated comments have been struck down by the courts, and I am not aware of evidence of improper enforcement actions against any lawyers or evidence that lawyers feel chilled in the practice of law under the existing rubric of rules. With regards to First Amendment concerns, we initially note that the freedom of speech is not absolute. Further, the speech of lawyers acting in a professional capacity has long been subject to additional restrictions that are viewed necessary to the integrity of the judicial system. Supreme Court has consistently upheld ethical rules enacted to regulate the legal profession's speech and conduct in the face of First Amendment objections. Also, some objectors argued that the knows or reasonably should know language of the model rule is unfair because it makes a lawyer liable for conduct that the lawyer knows or reasonably should know is harassment and discrimination. Their concern is that an attorney could violate the rule without actually realizing that he or she had done so. However, this standard is already widely used throughout many rules of professional conduct in many states. For instance, in the DC bar rules, the terms knows and reasonably knows have been defined. Also, those terms have been already used in 6 different rules in the District of Columbia rules of professional conduct and in another 6 different comments, and its scope and applicability has never been questioned. For example, those terms can be seen in rules 2.3b, 3.4a, 3.6, 3.8, 4.3, 5.1, and comments 1.0, comments to rule 3.4, comments to rule 4.4 and 5.1. In fact, the standard is appropriate in many instances addressing these type of definitions, and the failure to include reasonably should know language would in effect create a get out of jail free card for any lawyer pleading ignorance that certain words or actions are discriminatory or harassing. Other objectors raised the concerns that the term harassment and discrimination are vague. Although I don't agree with those concerns, many individuals who have adopted Rule 8.4G have taken additional steps to narrow rules by adding language such as directed to another person. Some objectors on the model rule stated that it applies to any conduct of an attorney that is anywhere related to the practice of law, which they believe is vague and not readily discernible. The term related to the practice of law is defined in the model comment number 5. Expanding the scope of the rule to include the practice of law is necessary to include conduct that goes well beyond the representation of clients before tribunals, because lawyers are managers of their law practice and public citizens have a special relationship to the administration of justice. They routinely engage in organized bar activities to promote access to the legal system and improvements in the law. Lawyers engage in mentoring and social activities related to the practice of law. The ethics rules should make it clear that the profession will not tolerate harassment or discrimination in all conduct related to the practice of law. In conclusion, it's important to note that the mission of any bar is to include fostering and maintaining high ideals of integrity and high standards of conduct. All bar rules across the United States must move to eliminate discrimination, harassment, and bias, not just in the courtroom, but wherever it occurs in conduct by lawyers related to the practice of law. ABA Model Rule 8.4 sets a standard for how members of the bar of a particular state should interact with others with respect to the practice of law. Lawyers who demonstrate bias and engage in discrimination in connection with the practice of law undermine and damage the profession, both by limiting opportunities for certain individuals to participate in the practice of law and by damaging the public's perception of the profession. Model Rule 8.4G would expand the existing prohibitions beyond the employment sector so that discrimination and harassment would be forbidden in any activity with respect to the practice of law, and would cover situations that are addressed by federal and state discrimination laws, though only where the conduct in question relates to the practice of law. Most importantly, Model Rule 8.4G also protects a lawyer's right to accept, decline, or withdraw from a matter. It also protects a lawyer's right to provide legitimate advice or to engage in legitimate advocacy. And it leaves unchanged any existing rule regarding peremptory challenges to jurors. The rules of professional conduct are rules of reason. They generally define the nature of the relationship between lawyers and others within the legal profession. The lawyers opposing this rule are applying an exacting standard that's usually reserved for criminal statutes in an attempt to argue that the terms of the model rule are unconstitutionally vague. We must not let this approach cloud the fact that the bar rules of most jurisdictions are meant to provide a framework for the ethical practice of law, and they should be viewed through that lens. Bar rules of jurisdictions across the US are not meant to be exacting criminal statutes. Moreover, the mission of the bar of any state should include to foster and maintain high ideals of integrity and high standards of conduct. To that end, it is important for every lawyer to take every effort possible to try and apply the principles of equity, fairness, and integrity to the legal profession within their state bar jurisdiction, and make every effort to make their state bar jurisdiction evaluate and adopt ABA Model Rule 8.4G. Thank you for your time.